Oh, Robert covered it all. Any questions? I have nothing to add. Thought this was my, never mind. Well, let me tell you a little bit more about the bill in a little further detail. It's called AB 1309, and it's a bill that was sponsored by all the major sports leagues and their insurance carriers. And the bill, if passed in its current form, would eliminate any player who was employed in his last year of employment from filing a claim in California for workers' compensation benefits for cumulative trauma injuries. Now, cumulative trauma injuries, for those of you who may not be familiar with the term, merely means, it's a technical and legal term, but it means nothing more than wear and tear over your entire career. Now, why that is an important right is probably the most serious problems you have in this room, and any football player has, and any professional athlete has, is the result of cumulative trauma. The classic case, obviously, is the brain injury cases. The brain injury cases have not become critical because a player had one or two diagnosed concussions during their career. It's the thousands of undiagnosed concussions that the player had. Every time you were hit hard enough, and what I'm telling you, by the way, is what neurologists say. This isn't my opinion, this is what neurologists say. Every time you were hit hard enough to cause you to be temporarily stunned, to just see stars, that was considered a low-grade concussion. So it's the thousands of these. Now, it was an interesting thing last year at this seminar when Kristen Willemeyer gave a report on the brain injuries. And she's with the Amen Clinic, and as some of you know, the Amen Clinic, one of their locations is Newport Beach, California, and the Amen Clinic ran a study of over 100 football players to determine what degree, if any, they were suffering from brain injuries. Virtually every one of them had some level of brain injury. And curiously, they decided they're going to see what position had the highest degree of brain injuries. I thought it would be like your modern day fullback, because he's blasting defensive linemen that often weigh 100 pounds more than him. I thought it'd be linebackers, because their contact comes at running 15, 20 yards at great speed, collide with a running back or a wide receiver. It was offensive linemen. And the reason was offensive linemen hit every play. And then I thought about it. It's not that you just hit every play, but you hit many times every play. Boom, boom, boom. You probably hit the defensive lineman 3 or 4 times on pass protection, for instance. So at any rate, cumulative trauma injuries are the most devastating long-term injuries. And the same type of long-term injuries come, for instance, orthopedically. It's the constant pounding that takes place over your career as you practice, as you lift weights, as you train during the off-season. And for those players who were unfortunate enough to spend most of their career practicing and playing on artificial turf, you know what that was like. It was towards the end of my career when we started. The Chargers didn't have an artificial turf, neither did the Raiders, but some of the teams did. And towards the end of my career, I played a few times on artificial turf. It was like playing on cement. It was literally like playing on cement, but I'm not telling you something you don't know. So in any event, the legislation is designed to eliminate cumulative trauma claims for any players who played out of state during their last year of employment. And the bill actually reads something like this: the only players who are safe, who play for out-of-state teams, from being able to file their claim are those who had 90 or more work days in California. You know how many that are? 0. Who comes into California and plays, and you're there for 90 days? It doesn't happen, whether it's baseball, basketball, football, or hockey. Now,
That's 90.
90 days under contract, I'm sure. Not 90, but the point is that
Is practice considered a day?
practice is considered a day. Yep, it is considered a day.
The season lasts, what, 6 months, 5 months?
Well, you know, teams come into. I mean, if you're playing in say the Western Conference in one of in the football division, you usually come into California maybe twice. You practice one day and you play the next. So you're never going to reach that 90-day level. Now, why were so many claims being filed in California? And for two reasons why California has been the place to file a claim. One, the statute of limitations. Every state has a statute of limitations. Usually it's 1 year. You have to file a claim within 1 year. You lose your rights forever. Some states it's 2 years. California has the same statute. But California goes a step further. California has recognized that it's not a benefit if somebody has workers' comp if they're not aware of it. And because every state places a duty on the employer to inform, I'm going to talk about specifically teams, but everything I tell you is general workers' compensation law that applies to all types of industry. So California progressively and rightly recognized that it's not sufficient to simply give the teams a duty to inform their players that they have a right to file workers' comp benefits if there's no penalty if they fail to give notice. So in California, if the team did not give, if any team that comes into California to play did not give the player notice of their rights and the player wasn't aware of his rights, then the statute of limitations suspended until the player finds out. So that's why we've been able to file claims for many of you who played 20, 25 years ago even. No other state has this. So that's number one reason. Probably the vast majority of claims are filed in California because the claims are barred in the state where the out-of-state player lived. California is one of the very few states, I believe there's approximately only 9 of them, that recognize cumulative trauma disabilities as being compensable. In all the other states, you have to prove that there was one specific dramatic incident that led to your problems. And the cumulative trauma claims, the claims that for brain injury, you wouldn't have a place to go. In California, you're permitted to file a claim for 2 types of injuries by statute. If there was a specific dramatic incident that caused the problem, or if part of your injury is a result of cumulative trauma. And in California, if you experience some of your cumulative trauma in California, you can bring a claim for cumulative trauma for all of it in California. And anyway, so that's why they want to get rid of it. So the major leagues and the insurance companies, they were able to put out a whole bunch of misinformation about this and convinced some legislators to support AB 1309. They said that these rich athletes had discovered a loophole in California laws that permitted them to file in California, and that it was causing a great deal of expense to California and a burden on their court system. Total lie. There's no loophole. The system that permits football players, basketball players, and whatever to file in California is the same system on cumulative trauma that permits your truck drivers, your migrant farm laborers, just anybody who on a regular basis or even a temporary basis comes into California and experiences part of their cumulative trauma in California. These exist by way of statutory law in California. It's not a loophole, it's something that exists. Now, it isn't automatic. You still have to prove by medical evidence that some of your cumulative trauma took place in California. So it isn't automatic at all. Now, the basic injustice of this type of AB 1309, I'm going to tell you about all the parts that are just uniquely unfair. It's shocking to the conscience. One, it's being made retroactive. And retroactive, that means it applies to existing claims, claims that were lawfully filed even 2-3 years ago, claims that have gone to trial already. I probably have 8 to 10 cases where we've gone to trial and won, and the insurance company and teams have appealed the cases, so they're not considered a final judgment. And if this is enacted before these become a final judgment, all those claims would be wiped out. One of my clients, Clyde Werner here, Kansas City Chiefs. Clyde's case has been around for over 1.5 years. Clyde has had all his medical evaluations. His case should be coming up for trial. Clyde's had 5 major back surgeries. He's had surgeries on each knee. He's had 3 Achilles tendon surgeries. He's due to have a left shoulder replacement. He filed his claim in California lawfully and rightfully. His claim could be wiped out by this legislation. Retroactive claim to be wiped out, it violates every concept of law that you can imagine. They're called ex post facto laws. In criminal law, they're automatically eliminated. You can't do it. It's an ex post facto law, meaning somebody has lawfully had a lawful right at the time they filed a claim and is then being taken care of. Joe?
I got a claim and I was awarded 88% disability, and then the Ravens, which were the Browns, they objected to it, but the judge said yes, she awarded it. Would I be able to also?
Well, is it final? Did they appeal?
I went to the trial, then they emailed me, good news, you got 88% disability, but the Ravens were going to contest it, but the judge gave me the claim of 88%, but I didn't collect the money.
It sounds like it's not final yet.
So that would be my
If there's no final judgment, meaning that the judgment's been issued and the time for appeal has exhausted, then yours could be wiped out if it hasn't become final prior to January 1, 2014, when the statute would become effective. Now, further, another form of injustice of this legislation. A player could spend the vast majority of his career with a California team or teams, and his last team is not in California. He could not file a claim in California. In other words, 90% of his cumulative trauma could have taken place in California, and he would be excluded from filing in California. Now, we brought that up as one of the obvious injustices, and to show you the disingenuous response that we got from these assembly people and presumably the leagues and the insurance companies, in response to that, they said they fixed that. And the way they fixed it, they said, is that if a player spent 8 years playing in California for a single team, you couldn't play for 2 teams in California for 8 years, 4 and 4 or whatever, had to be 1 team in California for 8 years, or spent 80% of his career in California, then he could file a claim. And that's just ridiculous. It would only benefit a few players. Other players, the vast majority of players, have played for more than one team. And so under the present bill, for instance, Junior Seau would not qualify. He could not file a claim in California. His heirs would not be able to file a claim in California now that it appears his death may have been football related. Look at all the other players. We probably just remember some of the bigger names whose careers did not end in California. Marcus Allen, LaDainian Tomlinson. We could probably go on and on and on. It's another injustice. Third injustice, it discriminates against a single set of employees, football players. That's it. Not football players, professional athletes. Only professional athletes have been singled out of all the professions. The highest injury rate of any industry in America is professional football and professional basketball. And they've been singled out to be eliminated from workers' compensation benefits that exist throughout America. There's a mandatory coverage to cover injured workers. Now, we know this. It may be that the leagues are only interested in eliminating professional athletes from filing cumulative trauma claims. But the insurance companies, I don't think so. For them, it's the athletes are first, but they're not going to be the last. The insurance companies have actually promised. They said, we're not going to go off after any other industries. But you know what? That's not their nature. That's not the way they operate. The way they operate is they love to collect premiums. They hate to pay benefits. Some of you are familiar, probably all of you are familiar with the story of the scorpion and the frog. I'll just tell it very quickly. Scorpion and the frog are on one side of the river. They're both interested in going to the other side of the river. And the scorpion says, let me ride on your back to the other side of the river. And the frog says, no, I don't think so. You'd sting me and we'd both die. And the scorpion said, yes, that's exactly why I would not sting you, because if I stung you, we'd both die when we're in the river. So the frog was convinced. The scorpion got on its back, about the middle of the river. Scorpion stung him. And the frog said, why? Why? Now we're both going to die. And the scorpion said, it's my nature. Well, it's the nature of insurance companies to try to get out of paying liabilities. You can bet that professional athletes were the first target. They're not going to be the last. The next target's going to be your truck drivers. It's going to be your migrant workers, farm workers. It's going to be anybody that suffers long-term disability. It's going to be firefighters. It's going to be police officers. Now, the impact of this bill is going to accomplish probably the true goal of the bill, and that is to shift the cost of medical care for athletes from the insurance companies, from the teams, to the public, to the general public, the general taxpayer in the states, because if the player is disabled and cannot work, he's going to have to apply for California Medicaid. If the player is disabled and cannot work, he's going to have to apply for Social Security disability and be covered by Medicare. And so it's going to be a cost shifting. And believe me, professional athletics do not need to shift the cost for anything. They're plenty able to pay for all of this. Now, an interesting question, who pays for workers' comp? Robert almost got it right. He said the players pay for it. That's almost right. For every league that has a collective bargaining agreement, and that's everybody but baseball, it has a salary cap, and that's everybody but baseball, in the collective bargaining agreement, before deciding how you're going to divide up the revenues, all the expenses are first considered. So in a very real sense, although technically the players don't write a check, in a very real sense, they are sharing the cost of their workers' compensation coverage. Baseball, it's the same thing, or any business. It's one of the expenses you take into consideration when you decide how much you're going to be able to pay your employees. In a very real sense, every employee is technically helping to pay for workers' comp insurance. Now let me tell you the misleading statements that are being made. And all the leagues and the insurance companies, they got out in front of this, and they got their PR machines working, and they gave out all sorts of misinformation, probably a long time before it really came to anybody's attention that this bill was going to be considered. First of all, they said that this costs California taxpayers. There's no kind way to put it. It's an absolutely lie. It's an absolute lie. The workers' comp system doesn't even cost California taxpayers anything, unlike the regular court system. The workers' comp system in California, meaning the payment of the buildings, the judges, the administrators, the employees, it's all paid for by employer contributions. So there's no general cost to California taxpayers when somebody gets an award. The payments come from the team the guy played for, if they have to pay some deductible. If not, it comes from the insurance company. They say it's a burden on the system. Again, it's a total lie. It's no burden on the California court system, the workers' comp system. If it was, so what? The California taxpayer is not paying for it anyway. The employers are paying for the work comp system. But it turns out to be not a burden. The presiding judge of Santa Ana Court gave a written sworn statement that it is not a burden on the system. Listen to this. If every football player today filed a claim for workers' compensation benefits in California, because approximately 750,000 claims are filed in California by other workers, it would amount to 1/5 of 1% of all the claims in California. Just ridiculous.
Why are they doing it?
I'm sorry?
Why are they doing it?
Why are they doing what?
Trying to disallow these claims.
Well, they still want to, because the insurance company wants to save money on payments, and the leagues and teams want to save money on premiums, and of course for any type of deductibility they have to pay on claims.
But it's 1/5 of 1%. That doesn't seem like.
No, it's 1/5. It'd be 1/5 for 1% of the claims. It doesn't mean that just means it's not a burden on the system. I'm covering something different. Now, an interesting thing, not only is it no cost to California taxpayers, when, as you guys know, when a player comes into California to play games, they have to pay franchise state tax on their earnings in California. In 2010, out-of-state players paid $162 million in California state taxes. It's projected to be approximately $300 million in 2014.
For all sports?
For all sports. For all sports, yep. They say another thing. They said so now they keep these lies that they've been telling have been exposed, and they keep having to consider that they have to concede that of what the truth is. So they keep finding new reasons to try to justify it. So they say it's because of STIGA, that's the California Insurance Guarantee Association. If an insurance company goes bankrupt and a claim can't be paid, then SIGA steps in and pays the claim. And SIGA is not paid for by California taxpayers, but it's a surcharge on all employers. So again, it's not California taxpayers, it's employers. But the proponents of the bill say, well, but you're making California less business friendly because it's costing the California employers more money to support SIGA. SIGA has paid an average of $4 million a year and on these claims for out-of-state players. And again, I'll tell you again, the players like 2009 or 10, they paid $162 million in taxes. I mean, I'd trade I'd take $4 million for $162 million any day. And we offered, by the way, as a compromise, we offered, all right, we'll make SIGA immune. They will not have any liability for out-of-state claims, or claims brought by out-of-state players. And they rejected it. They want to pass this legislation. Another thing, they said it's a bunch of rich athletes exploiting the system. Well, first of all, they have a legal right. Workers' compensation benefits belong to them legally. And if they are rich, why should the rich not claim their benefits as well as the poor? But it's not true, because it's not a bunch of rich athletes. The vast majority of athletes who are making these claims and are subject to them and would be affected by them belong to minor leagues. There's probably more minor league baseball and hockey and soccer leagues in California than anything else. There's certainly far more than major leagues. And the women's NBA, they'll be affected by this too. Let's see. And also, what's interesting is that many of these athletes, the vast majority are not rich at all, obviously, but many of them have been rendered poor because of the game, because of brain injuries, because of physical disabilities that make them unemployable or underemployed. So those are the type of people who need these claims. They say that it increases the workers' compensation premium rates for all employers in California. Again, the proponents of this bill are trying to draw the California connection, how it adversely affects California. And now their last resort claims are, well, it affects all of California businesses, because the number of claims cause the premiums to go up for the sports teams, and that causes premiums to go up for all industries. That's not true. It's totally false. Workers' comp premium rates are based on what's called experience situations. And so the number of claims in one industry does not affect another industry. I'm going to take a water break. And besides, then they take another. Their last major lie is they say that the players are double dipping. They're filing in some other states, and then they're coming to California, and that is just not true. California specifically has a number of statutes that forbid double dipping, and of course, the major leagues are going to be watching the Dave Pear's blog, and I would tell the major leagues, look at Labor Code 4663 and 4664. Double dipping cannot take place. If a player has, for instance, recovered something for an injury in another state, that's going to be credited against whatever recovery the person might make in California, or that body part may be excluded from the claim. The thing is, all of these leagues have the ability to fix their own problems. And the vast majority of claims, for instance, the only reason, as I told you, they're filed in California is because of the statute of limitations. Because the teams breached their duty to inform the player of their rights. Had they informed all of you of your rights when you retired, when you were injured, you would have filed your claim at that time in that state. All the teams have to do, all these insurance companies have to do to win their claims in California, all they have to do is show up in court, show this notice that they gave to the player, show this form that they gave to the player telling him about his rights to workers' comp benefits. It never happens. It's not a coincidence it doesn't happen. It's evidence, a reasonable evidence, that there's a conscious effort by these teams all these years not to inform the player of their rights. If they inform the player of their rights, they know 100% of them will file claims. If they don't inform the player of their rights, they're hopeful very few will file claims, or the statute of limitations will run on the claims. All they have to do now to fix the problem in the future, just give the player notice of his right to workers' comp benefits. That's all. They'll file in the home state. They won't bother coming out to California. How they can further solve their own problems. They say it's an unfair burden on California teams. Let me just quickly, I won't go into the entire legal theory, but let's just say that a player plays 10 years under current law, 10 years with the San Diego Chargers, and then let's say he plays for New England for a year, but the team never comes to California. It seems unlikely, but let's say New York Giants, never comes to California for a game, so he had no injurious exposure in California, so that if there's no California connection with the injury, then California does not have the right to hear a claim. But California doesn't leave the player or the injured worker without recourse. The liability then relates back to the next team over which California does have jurisdiction, and let's say that becomes the Chargers. So they say that's an unfair burden on California team. Well, fix it. I mean, football, we all know they're a partnership. They're a partnership. Treat your partners right. Fix it. Major League Baseball has fixed it. Major League Baseball, the teams equally share in workers' compensation costs. They just share the total, whatever the total pool of the cost is, Major League Baseball shares. Treat your partners right and just share the burden. And by the way, the NFL has already fixed the problem that they see as a problem. They fixed it. They started inserting what's called a workers' compensation forum selection provision in contracts, some as early as the mid-90s, and every team now has this workers' compensation forum selection provision, which states the player must file his workers' comp claim in his hometown, in his home state. And these provisions have been upheld in several federal courts, and so the problem's already been fixed from the NFL standpoint. The other major leagues, they're all going to put that provision in their contracts now, so it's already fixed. So the only effect this is going to have really is that number one area of injustice by making this legislation effective against currently pending claims. The most evil thing that I can imagine when you're talking about a justice system. It possibly could be attacked, the retroactivity, because of constitutional means of lack of due process, possibly affecting the Commerce Clause, but I'm just saying it's tough and it's difficult. Robert kindly has suggested what you can do about it, and we're going to try to work with Robert to put something on the website. This bill did pass the California Assembly last week, last Thursday, or no, it was last Thursday, the bill passed. The Assembly, it still must pass the Senate. The Senate is going to be the bigger fight, and we have a chance to defeat it in the Senate, and that's where all our efforts will be. So we'll be giving Robert the identity of all the California state senators. We might be wasting our time by contacting the Republican state senators, but I don't think so. I think, for instance, that some Republican state senators would be interested in defeating this bill, or if it was not retroactive, and they may be interested in the fairness of it. If the bill went through to take care of what they saw as the problem, but with the injection of not making it retroactive, maybe we might even get some Republican support. So we'll be giving that information to Robert. I took up too much of the time. I wanted George to come in and tell you about efforts that he and I and about 23 or 4 other players did when we went to Sacramento about 2 weeks ago, and we met with what we did, we broke up into about 5 different teams, and we each of the 5 teams of 5 or 6 of us met with 8 different legislators and tried to educate them as to what the true facts were, the stuff that I'm telling you now. George, your turn. Thank you. Oh, sure.
What's your personal opinion about guys who have pending cases right now? Do you think that they're going to be able to get through A, and B, all new cases? What's your personal opinion when going up to Sacramento to
First of all, I have to tell you that the NFL Players Association has literally spent millions of dollars in trying to defeat these types of litigation, including other litigation that's taken place all around the country, and they employed a really outstanding lobbyist firm called Aaron Reed and Associates, and those of us attorneys who are active in this field, we funded the employment of the public relations arm of the Aaron Reed and Associates, and they're really very outstanding. They told us, so far they've been right on about what would happen. They told us that the bill would come out of it originated in the insurance committee. It was proposed by the chairman of the insurance committee. They told us that it would come out of committee. We could not defeat it in committee because generally they say, as a matter of courtesy, other members of the committee, if the chairman sponsors a bill, they let it at least come out to be voted on. They told us that would happen. They told us that we would lose in the assembly because it's sponsored by Assemblyman. They tell us we have a good chance with the state Senate. So I can just say that. I can't predict anything. I just don't know the mechanics of the political process well enough, but we have a chance. Well, it'll be presented to the state Senate sometime within the next 2 to 4 weeks, 2 to 5 weeks perhaps. If it passes, it won't be effective until January 1 of 2014. So any cases that have come to a final conclusion are safe, or anybody that falls within the safety net. For instance, if somebody, the last team they played for was a California team, that person is safe. If the last team somebody played for athletes signed their contract in California, that person is safe.
Okay, I don't want to be specific, and this is about me, because I played 8 years in LA. I got traded in Buffalo. I just filed my workman's comp last month. I go to California in July to see all four doctors. When did we ice me?
I have to ask you a couple more questions. When you left the California team to play for the other team, did they trade your contract? Were you still playing under that contract?
No, I signed a new contract.
And where were you when you signed it? This is designed to wipe you out. But yeah, and that's correct. David's right. If for instance the team waived you and the out-of-state team picked you up on waivers, then you would very likely be considered what's called a California hiree, and you might be safe. I don't know enough about your case to give you an opinion. You really should check with the attorneys that represent you. Way back there.
What about being allocated to NFL Europe?
There's too many. There's too many different factual situations. There's too much I'd have to know to be able to give you an opinion. Where were you? Where were you at the time you were allocated? And the Raiders allocated you? You might be okay. Yes.
You should speak up so we can all hear you.
I thought one of the criteria for working, working comp in California, is if you had an agent that was based out of California.
Well, that's up in, the question was, is it if one has an agent alone, if that alone is the California connection? There has to be a California connection in order to file a claim in California. And one of the question was, is having an agent alone sufficient, a California agent sufficient to give California the right to hear the case? And there are cases up on appeal on that right now. In the past, it was generally accepted that if a person had a California agent, that was sufficient. There have been some cases that have come down that say otherwise. I recently had a case that came back on appeal that suggests that maybe it is enough. I'm just telling you, it is so up in the air, it's impossible to tell you what will ultimately happen. Yes, sir.
You have a trial next month, but I need to say, is that what you have a trial or not? If you don't have a decision by January, you really have not.
It's worth it to have the trial because, well, it depends. There are some things that I don't want to say for public consumption as to things we consider about whether taking a case to trial or not. Let me just say generally speaking, without knowing anything about your case, it may be worthwhile to take a case to trial and hope the judge reaches a decision before January 1, 2014, and further hope that they don't appeal the decision. Because one thing you can count on, there'll be some insurance companies, even if they know that under normal circumstances they'd lose the appeal, will file the appeal so that the judgment is not final, because appeals it could take anywhere from 8 months to 2 years or more. It's scary out there. Yep. Your attorneys really will know what's best for you.
Ron, let me ask you a quick question. It seemed to me when I won my case back in the 80s, was there 2 appeals? It seems like they appealed and we won and we went through another one. Was that?
There's 3 levels of appeal that could happen, and so the stalls can go on and on forever.
Yeah.
The first appeal is heard by the Workers' Compensation Appeals Board. The second appeal is heard by the Court of Appeals of the State of California, the civil court. The third level of appeal, technically it could be 4 levels of appeal. The third level of appeal is the California Supreme Court, and of course the 4th level of appeal would be the United States Supreme Court.
You know, actually, it was,
You better take over and
no, it was actually
give your
3 appeals, and now that you brought it up to my
Yeah.
attention, because they just kept going on and on and on and dragging it out. So if these guys are in the appeal process and we hit that July 2014 date and they haven't settled,
January 1,
Or January.
2014, if it passes in its current form, the claims of those guys will be wiped out.
wow. Unbelievable. After winning your case and going to appeal after appeal, you could still be wiped out.
So
No.
then why wouldn't they not appeal?
Oh, that's exactly it. They will. They'll appeal everything.
Yeah, you have to expect the worst. I will say this, and I won't comment on which insurance companies and which law firms, but there are some insurance companies and some law firms who I don't believe will participate in that type of stalling tactics if they've lost the case.
You're kidding.
Really. I will say this personal experience that the 49ers work comp, the travelers, will take you as far as they possibly can. They just actually tried to close out my case. Most of you know my case real quickly. Those of you that maybe came in late, I suffered, I developed hydrocephalus during the 81 Super Bowl season. I had emergency VP shunt brain surgery, 2 more, 4 months after the Super Bowl, and now I'm on my 9th brain surgery over the years. But it has been a knockdown, drag-out fight for me every step of the way, and some insurance companies may be different. I think, like you said, maybe once they win, you win, and then they follow the law. In my case, it has just been an absolute nightmare for 30-some-odd years. In fact, they tried to settle me. They wanted to close me out a little over a year ago, and sat down with my wife and I and offered us, basically probably 3 days worth of, in the hospital. They wanted to put $30,000 in an endowment account, and they would put $6,700 in every year to pay medical bills. They were going to pay me $1,160 a month, guaranteed for 15 years, whether I was dead or alive. And then they were going to pay us a whole $73,000 to close out my case. Now I have well over $1 million in hospital bills over the years, but again, they try to take advantage of the situation. They know that we are hurting financially, So I think what I'll touch on here is, and bear with me because I'll lose my train of thought sometimes going through some of these things. But pardon? Okay, how's that? So just bear with me, and if I repeat myself, sometimes I will have a tendency to do that. But what do we got? Oh, there we go. Thank you. I'm also technologically challenged, so when I'm used this high-tech equipment like this, I have problems. But bottom line is that these are earned benefits. They're not anything that we're looking for. It's not a handout. And again, correct me if I'm wrong, that the insurance policies are paid out of the collective bargaining agreement where that chunk of money is allocated to pay for each team's insurance. Isn't that correct? So basically, the players pay for the insurance that we can't access. It comes out of your chunk of the collective bargaining agreement, which, whatever it is, 49% to the players and 50, I don't know exactly what it is, but the players pay for it, and yet they deny us access to it. And that's basically the bottom line, how this whole system works. So, there's a lot of things going on. We were both down at the Capitol 2 or 3 weeks ago. It was great. We had, like Ron said, we had about 5 or 6 different teams, maybe 7 teams. Also, I brought the handout that we had there. So if anybody wants, there's several pages in there. If anybody wants copies of that, come and see me. I'll bring it down and we can take it somewhere and they can get it copied up. Be well worth taking a copy with you.
Can you put it on Dave Fair's website?
Yeah, we could scan it.
Something like that?
Yeah, we could scan it, put it on the website. Great idea. Just remind me, because I'll probably forget. So, there's a lot of things going on right now. We have that pending, and then I just spoke last week at another down at the Capitol. The Brain Injury Association of California has a bill sponsored by Senator Beal. It's SB 320, and basically it'll allow anyone with a traumatic brain injury to get treatment from any existing facilities that are structured for that. Right now what happens is the insurance companies can yay or nay it. Even though you have a doctor that says that you need to go see XYZ, the insurance company may say, no, we're only going to let you go over here or there. So this bill here will allow anyone with a brain injury access to any accredited, treatment facility that's been prescribed to you. So this just passed on to the next step. We went, like I said, just got an email last night. It went 5 to 2, so it's going to the next, I think, to the Appropriations Committee, I believe, is the next step. I'm not totally up to speed on how this stuff works, but so I think that's going to help us out too, because this is another work comp issue that's in front of the senators. And again, we had an opportunity to sit down, and I met with some of them face to face, some of the policymakers, like we did when we had the whole group there. And I think one of the most important things is that we need to just keep this, people need to hear our stories. When we had our meeting with the on the players situation, I sat down at lunch. We had a lot of the senators and policy folks there, and I sat down with Senator Perez sits down with me, and I introduced myself, and we start talking, and he said, "So what brings you here?" And I said, "Well, my 9 NFL-caused brain surgeries and no NFL benefits." And he was shocked. And I said, "Why are you shocked?" I said, "Where have you folks been?" He said, "I had no idea this was going on." I said, "Well, you know what? You guys need to hear, and they need to hear from us. No one has any problems talking about, you blew your knee out 16 times and you had 3 elbow surgeries and blah, blah, blah. But no one wants to talk about the head injuries, because it comes back and it bites us in the ass. You go to get a job, and all they hear about is brain damage, brain damage, brain damage, But until we get more and more people, guys stepping forward, and I love seeing the families here, the wives and the daughters that get hammered by what happens to us, and we all think we're okay, and I learned many, many years ago. I go into doctor's appointments, and I live out of these things. Guys, I have 30 years of these. I'll have 15, 20 pages a day I have to write down everything that goes on in my life. I read back through it every 2 or 3 times a week. I'll read the week or 2 prior, trying to reinforce in my memory what went on. It's just like doing reps, in practice. But I learned a long time ago, too, that even before I got married, and I was almost 40 when I got married, I would take my older brother with me to doctor's appointments. And we would hear things differently. I'm writing down notes, and I walk out of there, and I said, "Hey," he says, "I'm good to go." And he'd look at me, and he'd say, "What are you talking about? Didn't you hear him say, this?" And I would hear what I wanted to hear. I'd hear the good stuff. So now I take my wife. The first time we went down to Dr. Amon's clinic, I was down there for 3-day, full-blown, 12-hour-a-day neuropsych evaluation. I took my son, who was 9, and I took my wife, and I wanted them to be, when I wasn't around, I said, "You go in and you tell them what I'm like." And that gives them a whole different perspective. Because we are always, it's ingrained in us, we're warriors, and you suck it up and you're good to go. I'm telling you guys, we're not good to go. But I will tell you this, that there are treatments available. Now, until just a couple years ago, the scientific data was once you're brain damaged, that's it. Brain cells don't heal, you don't regrow any new ones. Well, the latest buzzword now is neuroplasticity. Okay, we only use about 5% of our brains. And some of us probably a lot less than that. But what they're finding out now is that if you do things out of the ordinary, if you're right-handed and you force yourself to start writing left-hand, I mean, they'll put electrodes in and new areas of your brain start firing up because you're doing something out of the ordinary. And that causes new neurons to grow. They didn't think you could grow new neurons, but you can. And you can activate ones that aren't being used. So doing things out of the ordinary, driving home from work every day, a different route that you have to think about it. It's like, okay, it forces your brain, other areas of your brain to crank up. I've had great results, with hyperbaric oxygen treatments. Some of you met me 3 years ago when we first started this thing. 3 years ago, I was on 4 different dementia medicines at once, on top of anti-seizure meds, on top of taking a handful of Ambien every night to try to sleep. And I've gone up to 4 nights straight with not a minute's worth of sleep due to inflammation in your brain. I got into the hyperbarics. I take 12 to 16 grams a day of just omega-3 fish oils. That reduces inflammation. I take concentrated cranberry, blueberry, ACI juices. Those are tremendous antioxidants, reducing inflammation. I'm working on a lot of things to try to get my life back in order. And I have data from my 3-day exam down at Amon's clinic 3 years ago, all my full-blown microcognitive memory scores and all that, and in every 40 hyperbaric treatments, I go back down to Amon's and I get reevaluated. I've been down there 5 times in the last 3 years, and my microcognitive memory scores have improved over 15%. That's substantial. I mean, I'm going on 55 years old, and my memory has improved 15% in the last not even 3 years. So there are ways to come back from this. I don't know if I'm getting off track here, but these are some of the things, this has been my life. I was 22 years old when this started. And I don't know any different what it's like to not have to live out of these things. Perfect example is this conference. We've had this plan for how long? Since last year. In order for me to remember to get here, I have beepers go off at every month, 3 months prior. The last month, I had a beeper go off every week. The week before I came down, I had a beeper go off every day. And the day I was leaving, which I think I left at 2 or 3 that afternoon, I had my beeper go off every hour. And then every 15 minutes, the last hour I needed to leave. Because honest to God, I will have all those things go on and on and on and on, and then I'll get distracted at the very end, and I'll forget. And a perfect example was I was just last week, maybe last Friday, I was keynote speaker at San Joaquin Valley College nurses graduation. And I had my usual reminders going off. But any questions on anything? I've been through the work comp for 32 years. I used vocational rehab. When I won my work comp case, I used back in 84 or 86, whenever I won it, they offered me $35,000 to go away. And I said, no, thank you. I didn't take any money, but I kept my medical open, and I used voc rehab to return to school to finish my biology degree. In one 10-month period when I was back in school, I had 4 more brain surgeries. So it took me 5 more years to complete my degree. I was 32 when I finally graduated. But so there are tools there that are set up for all injured employees, and that's what work comp is all about. And again, keep in mind, these are earned benefits that we've all earned. These aren't handouts. State of California is trying to make it sound like it is. We're coming in and to be a burden, but like Ron touched on, this isn't, we paid for this. So again, I'm probably getting off track here, but any questions?
What was the 2 or 3 weeks ago? What was the pulse? What did you get back from doing the cruise? And what was the feedback you were getting back from your audience?
I think when we had the face-to-faces, pretty much every group I was in, every policymaker I spoke to, they were shocked at what's going on. And that's where I asked them, I said, where in the hell have you folks been? I mean, really, they've been doing this to us for decades. And Congress just steps back and antitrust exemption and nonprofit, I mean, give me a break. $9.5 billion industry, and they can't throw a few little crumbs into a non-wasting endowment account to fund some retirement for some of the guys. So I think it was, didn't you feel the same, that we had a great response from everybody?
I can't share that opinion. I can just tell you this, that every legislator that we met with, a number of them were not informed about what the true facts were, but every one of them was polite, they listened, they were friendly, but believe me, you cannot get a read on how they're eventually going to vote. And we primarily met with people in the assembly because that's where the first vote was going to take place. And the proof, as they say, was in the pudding, because the assembly overwhelmingly passed the bill. But our lobbyists and our PR people said that would happen. We're hopeful that there's going to be a different result when it's presented to the California State Senate.
Well, what is the vote? Do you know the numbers?
Yeah, the numbers were 57 to 2. 57 in favor to 2. It's not as bad as it sounds. 27 did not vote. And so the 27 who did not vote were people that were against it, but they didn't want to vote against the chairman who was of the insurance committee who was sponsoring the bill.
So it's even worse.
No, it's. I can just tell you, according to our experts, we have a much better chance in the Senate.
Why? Why is it better in the Senate? What's explaining their...
Well, the bill isn't sponsored by anybody in the Senate. That's the main thing. So there isn't anybody in the Senate who owes any obligation to the sponsor of the bill, and who may vote for it out of courtesy, for instance, or because the person has helped them raise money for their campaign.
And I have a question for you now. Senator Pereira, right? He sponsored it. Was it? And I've been asked this many times. What was what was driving him to sponsor this bill?
Senator or assembly person? Pereira's assembly or...
He's assembly, I believe. The question was, what is driving him to sponsor the bill? I have no idea. I mean, I truly have no idea. You can speculate on a lot of things, and I don't wish to speculate for public consumption. I will share with you privately what I feel when we visit.
Ron has a lot more constraint than I do. I have a tendency to run off my mouth what I'm thinking. So, anyone, any more questions? I want to take one minute. Where'd Robert sneak off to? Okay, I just want to acknowledge Robert, the work he's done for us. That man has probably done more for the retired players than the total of anyone in our group has done in the last decade or so. So I just want to give Robert a little pat on the back, but he's not here, so.
Boom 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 boom.
Raiders, but some of the teams did. Towards the end of my career, I played a few times on artificial turf. It was like playing on cement. It was literally like playing on cement, but I'm not telling you something you don't know. So in any event, the legislation is designed to eliminate cumulative trauma claims for any players who played out of state during their last year of employment. And the bill actually reads something like this: the only players who are safe, who play for out-of-state teams, from being able to file their claim are those who had 90 or more work days in California. You know how many that are? Zero. Who comes into California and plays, and you're there for 90 days? It doesn't happen, whether it's baseball, basketball, football, or hockey. Now,
That's 90.
90 days under contract, I'm sure. Not 90, but the point is that
Isn't practice considered a day?
practice is considered a day. Yep, it is considered a day.
The season lasts, what, 6 months, 5 months?
Well, you know, teams come into. I mean, if you're playing in say the Western Conference in one of the in the football division, you usually come into California maybe twice. You practice one day and you play the next. So you're never going to reach that 90-day level. Now, why were so many claims being filed in California? And for two reasons why California has been the place to file a claim. One, the statute of limitations. Every state has a statute of limitations. Usually it's 1 year. You have to file a claim within 1 year. You lose your rights forever. Some states it's 2 years. California has the same statute. But California goes a step further. California has Oh, Robert covered it all. Any questions? I have nothing to add. Thought this was my, never mind. Well, let me tell you a little bit more about the bill in a little further detail. It's called AB 1309, and it's a bill that was sponsored by all the major sports leagues and their insurance carriers. And the bill, if passed in its current form, would eliminate any player who was employed in his last year of employment from filing a claim in California for workers' compensation benefits for cumulative trauma injuries. Now, cumulative trauma injuries, for those of you who may not be familiar with the term, merely means, it's a technical and legal term, but it means nothing more than wear and tear over your entire career. Now, why that is an important right is probably the most serious problems you have in this room, and any football player has, and any professional athlete has, is the result of cumulative trauma. The classic case, obviously, is the brain injury cases. The brain injury cases have not become critical because a player had 1 or 2 diagnosed concussions during their career. It's the thousands of undiagnosed concussions that the player had. Every time you were hit hard enough, and what I'm telling you, by the way, is what neurologists say. This isn't my opinion. This is what neurologists say. Every time you were hit hard enough to cause you to be temporarily stunned, to just see stars, that was considered a low-grade concussion. So it's for injury as a result of cumulative trauma. And in California, if you experience some of your cumulative trauma in California, you can bring a claim for cumulative trauma for all of it in California. And anyway, so that's why they want to get rid of it. So the major leagues and the insurance companies, they were able to put out a whole bunch of misinformation about this and convinced some legislators to support AB 1309. They said that these rich athletes had discovered a loophole in California laws that permitted them to file in California, and that it was causing a great deal of expense to California and a burden on their court system. Total lie. There was no loophole. The system that permits football players, basketball players, and whatever to file in California is the same system on cumulative trauma that permits your truck drivers, your migrant farm laborers, just anybody who on a regular basis or even a temporary basis comes into California and experiences part of their cumulative trauma in California. These exist by way of statutory law in California. It's not a loophole, it's something that exists. Now, it isn't automatic. You still have to prove by medical evidence that some of your cumulative trauma took place in California. So it isn't automatic at all. Now, the basic injustice of this type of AB 1309, I'm going to tell you about all the parts that are just uniquely unfair. It's shocking to the conscience. One, it's being made with thousands of these. Now, it was an interesting thing last year at this seminar when Kristen Willemeyer gave a report on the brain injuries. And she's with the Amen Clinic. And as some of you know, the Amen Clinic, one of their locations is Newport Beach, California. And the Amen Clinic ran a study of over 100 football players to determine what degree, if any, they were suffering from brain injuries. Virtually every one of them had some level of brain injury. And curiously, they decided they're going to see what position had the highest degree of brain injuries. I thought it would be like your modern day fullback, because he's blasting defensive linemen that often weigh 100 pounds more than him. I thought it'd be linebackers because their contact comes at running 15, 20 yards at great speed, collide with a running back or a wide receiver. It was offensive linemen. And the reason was offensive linemen hit every play. And then I thought about it. It's not that you just hit every play, but you hit many times every play. Boom, boom, boom. You probably hit the defensive lineman 3 or 4 times on pass protection, for instance. So at any rate, cumulative trauma injuries are the most devastating long-term injuries. And the same type of long-term injuries come, for instance, orthopedically. It's the constant pounding that takes place over your career as you practice, as you lift weights, as you train during the off-season. And for those players who were unfortunate enough to spend most of their career practicing and playing on artificial turf, you know what that was like. It was towards the end of my career when we started. The Chargers didn't have an artificial turf, neither did the. Recognized that it's not a benefit if somebody has workers' comp if they're not aware of it. And because every state places a duty on the employer to inform. I'm going to talk about specifically teams, but everything I tell you is general workers' compensation law that applies to all types of industry. So California progressively and rightly recognized that it's not sufficient to simply give the teams a duty to inform their players that they have a right to file workers' comp benefits if there's no penalty if they fail to give notice. So in California, if the team did not give, if any team that comes into California to play did not give the player notice of their rights, and the player wasn't aware of his rights, then the statute of limitations suspended until the player finds out. So that's why we've been able to file claims for many of you who played 20, 25 years ago, even. No other state has this. So that's number one reason. Probably the vast majority of claims are filed in California because the claims are barred in the state where the out-of-state player lived. California is one of the very few states, I believe there's approximately only 9 of them, that recognize cumulative trauma disabilities as being compensable. In all the other states, you have to prove that there was one specific dramatic incident that led to your problems. And the cumulative trauma claims, the claims that for brain injury, you wouldn't have a place to go. In California, you're permitted to file a claim for 2 types of injuries by statute. If there was a specific dramatic incident that caused the problem, or if part of your